Well, a number of audio leaks involving high-ranking politicians, judges of the Supreme Court and their families have recently surfaced, and given the people that such audio leaks have involved, these audio leaks have unsurprisingly engendered a lot of questions and have piqued a lot of people's interests. Now, the fundamental question that arises from these audio leaks is that can eavesdropping such conversations and can listening to such conversations be legally condoned? And the simple answer to this question is no. And this is not just my answer. My answer emanates from the Supreme Court's own judgment. So in Benazir Bhutto's case in 1999, the Supreme Court had said that eavesdropping conversations, listening to such conversations, and then recording such conversations is not only morally reprehensible, but the same also offends the fundamental rights enshrined in the Constitution. So Article 14 of the Constitution talks about the right to privacy. And the right to privacy includes the right to have my private communication protected. So recording such communication and then leaking such communication, while it also offends the fundamental rights espoused in the Constitution, it is also violative of a number of other laws. Now, the question, we recently saw that the federal government had also constituted a commission to determine the authenticity and veracity of these leaks and then to affix responsibility on those people who were involved. There was also the terms of reference of the commission also included determining if such audio leaks had compromised the right to fair trial of certain parties or the administration of justice. But interestingly, the terms of reference of the commission did not include one fundamental question, which is, could such conversations have been recorded? And if not, then what action should be taken against those who were illegally and unconstitutionally recording such conversations? Now, I believe that while these audio leaks may raise a number of interesting questions, but all those questions are secondary, because the first question is that could such conversations have been recorded? And as we discussed earlier, the Supreme Court has previously said that these conversations cannot be recorded. So any other question that emanates from these audio leaks is irrelevant if these audio leaks could not have been relied on. And throughout the world, in any modern society, in any civilized democratic dispensation, we see the principle of fruits of a poisonous tree being developed and evolved. And that doctrine, the doctrine of fruits of a poisonous tree, espouses that any evidence that is procured illegally cannot be used for any purpose. So given that these recordings were procured illegally and these recordings cannot be used in any court of law or before any commission,